because I'd like to make the arguments and be able to resolve this today. I don't believe in setting this out another couple months. These kids' lives have been on hold for too long. Good morning, everyone. We are on in the matter, case number D23671-029V. May I have your appearances for the record?
Good morning, Your Honor. Patricia Warnock, bar number 14432, on behalf of who are present to my right.
Thank you and good morning.
Good morning.
Good morning, Your Honor. Lisa Szyc, 11726, on behalf of defendant who is present in court today.
Thank you. Good morning.
Good morning, Your Honor. Sheila Tajbakhsh, bar number 15343, here on behalf of Natural Father, who is present to my left.
Thank you, everyone, and good morning. Okay, we are on for, I see we have here a respondent. I believe we have a couple motions here. I do want to note for the record, we do have our Nevada judges filming. They did receive permission, and they did file an order for camera access to court proceedings and media requested order for this matter. Before we go into the arguments, has there been any resolution?
No, Your Honor.
Okay, not a problem. So we'll go ahead and Ms. Szyc, I believe this is your motion?
Yes, Your
So
Honor.
I'm going to give you 5 minutes, and then I'll give up both other parties 5 minutes to go ahead and present their arguments.
Thank you, Your Honor.
Thank you. Everyone else may be seated except for that who's speaking.
And Your Honor, this is motion for reconsideration. When the initial petition and motion by the grandparents was filed, was appearing in this matter pro per. She had different counsel in the divorce action, and since then I have substituted into that matter. She was under the mistaken belief that counsel in the divorce action would also appear for her in this matter. She did not understand that counsel in the divorce action and this grandparent action were two separate matters. Therefore, there was no appearance made and no opposition filed to the matters that were made in this grandparent action. The motion for reconsideration has been filed to ask the court to reconsider the order that was issued and to give her an opportunity to file an opposition to the motion so that she can be fully heard on that matter. I think it's appropriate. It was timely filed. The notice of entry of order to the motion filed by the grandparents in this matter was December 26th. Her motion for reconsideration was filed on January 9th. That's within the 14-day time period. The motion should be heard on the merits. Should be given an opportunity to fully be heard on that underlying motion so that the matter can be heard. It is in the best interest of the children to allow the motion to be heard on the merits. And because it was timely heard and she was a pro per party at that time, I do think it is appropriate for the reconsideration motion to allow her to be heard and to give her an opportunity to fully oppose the grandparents' motion. And on that, I'll submit it.
Thank you, Ms. Szyc. Okay, Ms. Warnock?
Thank you, Your Honor.
You're welcome.
So, Ms. motion for reconsideration fails to establish one of the 3 grounds required for a motion for reconsideration: the availability of new evidence not previously available, the intervening change in controlling law, or a need to correct a clear error of law or prevent manifest injustice. She doesn't meet any of the requirements. Mom had the opportunity to oppose the motion. She did file an appearance. It was pro se. She didn't file an opposition. She didn't show up the day of the hearing. She had plenty of opportunity to oppose the motion. She chose not to. And then, on top of that, she was late in filing her initial pleading in the case. And then they filed their reply 36 hours before the previous motion, Your Honor. And didn't provide all of the exhibits until less than 24 hours before the motion was originally scheduled for this. Your Honor, you made findings of fact on the record. You also made, we had a behavior order put into place. You admonished the grandparents on the record what was appropriate to talk about in front of and what was not appropriate. Since then, there's been no problems, no changes. There has been no changes in circumstance since the initial pleading was filed. The exhibits that they filed with their reply were all taken 9 months ago or so, and that was before my clients retained counsel. And since then, we've had conversation about what's appropriate to discuss in front of the minor child, and since then, you've also put a behavior order on the record, Your Honor. We like to keep things as they are, excuse me. You did go ahead and grant some time to the grandparents. This was a temporary order. The parties have their divorce action scheduled for April, and we have a return hearing after that date. So we'd like to leave it status quo, Your Honor.
Thank you, counsel. Ms. Tajbakhsh, anything to add?
Thank you, Your Honor. I actually joined in Ms. Warnock's entire argument. My client doesn't really have much more to add. The only thing we would request is at this time the court once again admonish Mom for the verbiage she uses in her pleadings, the adjectives she uses to describe my client. She's already been warned about this several times in the underlying divorce case. This pleading was no different than those other pleadings that have already been stricken from the record. Not only that, this is clearly just meant to harass my client at this point. So if we want to argue the issues, we can argue the issues, but these pleadings, this needs to stop, Your Honor. It's absolutely ridiculous.
Okay, thank you. Okay, and Ms. Szyc, you want to add any brief rebuttal? Very brief.
Your Honor, again, the only thing that I would establish is that the grandparents' claims are derivative claims from the parents' claims, and again, the Miss was proper in these proceedings, and it is appropriate to give her an opportunity to be heard. She did not appear in this. She appeared in this matter proper, and it's appropriate to let her be heard and file an opposition on the underlying motion.
Okay, I'm familiar with this case because I do have the underlying custody matter between Mr. and Mrs. I'm very familiar with the criminal action and the disposition thereof. I know we've had several conversations when we had the custody matter when Mr. Schneider was representing Mrs. and Ms. Tajbakhsh, and we were at that time very concerned about any inculpation of testimony by Mr. in this court that could be used against him in the criminal court. So I am very familiar with this case. I'm also very familiar with the history of Mrs. vis-a-vis Mr. and Mrs. the grandparents. I'm familiar that the grandparents were granted in the custody case, the underlying case, an opportunity to have visits and opportunity to include picking him up, taking him to school during Dad's time, because at the time Dad, I believe he still is prohibited from going to the school due to the underlying criminal matter. And so I am familiar with this case, and I am aware that Mr. was represented by Mr. Schneider in the underlying custody matter. And so in this matter here, when I did call this hearing, I believe our hearing was in December 5, on or about December 5 when we had the hearing. I was actually surprised that Mrs. wasn't here. And I think I asked to call in the hallway to check over here to see if she was appearing on Blue Jeans. And so, Ms. Szyc, I was concerned. I'm not sure if you are filing a motion for reconsideration or a motion to set aside, because it seemed like some of your arguments were more on the set aside and RCP 60B mistake, inadvertence. She didn't appear. But I see that instead of making a 60B argument, you requested a reconsideration argument instead. Because I do recognize that the underlying policy is, of course, to hear cases on the merits, especially when it comes to divorce actions, custody matters, especially in a case as sensitive as this. His best interest is my utmost priority, and I do believe that he has a mom who is very protective of him as well as of his sister, because he is in the home with his sister. I also believe, though, that he has a father and grandparents who love him dearly, and grandparents have been at almost every hearing. Even when I had my behavioral orders in place and mentioned to them that you're not to discuss the case, you're not to discuss the criminal case with or the sister, or discuss the sister's name in the case. So I'm putting this all as foundation because I want the record to establish this court's history with this family and the underlying concerns. And so while I do recognize there's not new evidence per se, and I don't believe you're arguing that I made a clear error or manifest error in the law, I do believe that would be a manifest injustice in denying Mrs. an opportunity to state her case. I do believe that she has been consistent throughout the underlying custody proceedings in her position, and so she does deserve to have her day in court, especially considering that she was the primary caregiver of, as well as she is a protector of her daughter, who's not in this custody case, but of course is another interest that has been discussed throughout these proceedings. But in the interest of judicial economy, if I were to set this for another hearing, it would be months out, and I would like us to be able to resolve this matter today. So I'm going to grant the motion for reconsideration, but Ms. Szyc, I'm going to ask you to make your arguments now. I believe you made most of the arguments already. I don't believe there's anything new under the sun. If there is anything new under the sun, then of course state your case and I'll give you a time to make those arguments. But I believe that with this court's familiarity with this case and everyone's familiarity, I would like, in the interest of justice, to proceed today with the ruling. So I did read your reply, I did read your arguments, I read your exhibits, I looked at everything. So I'm gonna go ahead and grant the motion for reconsideration to give your client her day in court on the condition that it's today. Because I'd like to make the arguments and be able to resolve this today. I don't believe in setting this out another couple months. These kids' lives have been on hold for too long. So Ms. Szyc, are you prepared to make your arguments now?
I am, Your Honor.
Okay?
Okay, so with that, may I proceed?
Absolutely.
Thank you. Based on the best interest factors that were set forth in the motion for reconsideration and the fact that the court has read them, I think that the order that was issued, I believe it was dated December 26th, I don't think that it is necessary for there to be a separate visitation schedule for the grandparents. As the court just indicated, there was a consideration for the grandparents in the underlying custody case. The grandparents are afforded visitation time in the custody matter. Not to mention, the grandparents' rights are derivative of custodial time for Mr. There is no indication of any facts in this case that either mom or dad are depriving Mr. or Mrs. grandparents of any time with. And under the statute affording grandparents visitation rights, there has to be some indication that they are being deprived of time with their grandchildren because of some act of the parents. Those facts just aren't here. So there does not need to be a separate grandparent petition. There does not need to be a separate grandparent visitation schedule. There's no facts here to support that there needs to be a separate order affording them a visitation schedule when it's clear, as the court has just indicated, there's time worked into there for them to see with Mr. time in the custodial case, and there are no facts that have been indicated anywhere in either this case or in the underlying custodial case to indicate that either or Mr. have interfered with their ability to have a loving and caring relationship.
Yeah, I guess that is the crux of the question. What is the, I know that grandparents are afforded opportunity to take them to and from school. And I believe that in our December 5 hearing, it was agreed that their weekend rights, their weekend visitation would be derivative of dad, so it would be during dad's time, so as not to prejudice mom and take the child away from mom. The only addition was, so we're not really contesting that. I guess I'm trying to boil down to what are we really contesting, because the weekend visits are derivative from dad. That one is correct. I think we're looking at the Wednesdays. They asked for one Wednesday a week, so is it really boiling down to the one Wednesday? And then I think it was also a week in the summertime. So let's call it for what it is. It's not the weekends. The weekends are fine because they're derivative from dad. Is it the Wednesdays that we're contesting because their visits should essentially derive from dad's visits?
We're contesting the need for an order, period.
Okay.
Like there's been nothing to support that there needs to be court interference for grandparent time at all. Because again, there's been no indication that has interfered with this relationship. Dad is not contesting this relationship. Dad has custodial time with dad. Like again, it's a derivative relationship. The statute supports that. The case law supports that.
Yeah.
There's no interference here, so there's no basis for this order.
Okay.
That's our position.
Okay, and I do see that in the statute now that you're making your position. You weren't here, so that was very different when I didn't have a position from this. But I do agree, typically third-party visitation rights, i.e. grandparents' rights, derive from if the parent is denying them an opportunity to have that relationship. And you know, the law presumes that if a parent is denying any third party, that it's presumed to be in the best interest of the child, and it would be the party contesting that would have the burden to establish. So the first hurdle would be, are they being precluded an opportunity to have a relationship by mom or dad in this case? So Ms. Warnock, I'll shift the burden over to you.
Thank you. So initially, if you'll recall, when we filed this, we didn't have access to the sealed case that was there. And on top of that, there was some supervised visitation going on.
Yes.
Since then, it makes my understanding, again, I still don't have access to that case because I'm not a party, right? You understand? But the grandparents' time has changed since prior to it.
Yes.
They were very involved grandparents. They spent the majority of the time with the minor child, more, just as much as mom, just as much as dad. They spent weekends, they spent summers, they spent all kinds of time. And I understand that their time is derivative, but the decision hasn't been made in the trial, in the divorce case, what is going to happen with them. And it's our belief that if mom is granted primary physical custody in that matter, that the grandparents are gonna lose all of their time. I'm sorry.
I completely understand. So in the one sense, you're preserving their right.
Preserving their right, and these were temporary orders, and they were minimal from what we requested. We asked for a lot, we got a little bit back, but we took it because they want every minute that they can have with their grandson.
Sure.
They love spending time with their grandson loves spending time with them, and we don't understand why it has to be such an issue. We did try to reach out and resolve this prior to filing our motion, but had no response whatsoever, Your Honor.
Okay, so tell me right now, I know that if I were to deny this order, what kind of time would grandparents have? Is dad denying them time?
Dad is not denying him time.
So go ahead, what kind of time does grandparents
So
have?
the grandparents get to assist in bringing him home from school.
Yes.
And the grandparents don't want to impinge on all of dad's time because they believe that dad needs to maintain that relationship with on their own. And they would like to have time, maybe that doesn't involve dad, that doesn't involve mom, that's that one-on-one time with their grandchild that they previously had. So right now they have the after-school time and I'm sorry, I don't know the rest of the time
That's
that Jason
I'll
has.
ask Dad. So I am familiar, I do know that they take
Right.
to and from
To and from
school
school.
during dad's time share.
Yes.
Okay, excellent, thank you.
Thank
Ms. Tajbakhsh, what kind of time share does your client have?
My client has, I believe it's every weekend but the third weekend of the month right now.
That's right, mom has a third weekend.
Yes, Your Honor. And it is true, the parents do help pick him up from school, but it's already limited time, and they don't want to interfere on his already limited time. I do believe there was a status check in this case set for after the trial in the divorce action, which was to address to see what happens in the trial, to come here and see if we do need to have an order. Just based on mom's counsel's arguments, I mean, I guess we're kind of wasting time here if we're trying to set aside something that wasn't a problem, right? So we had the status check. I'm not sure what the reconsideration was for. Mom made all her arguments in her opposition, in her motion for reconsideration and or set aside. At this point, I would ask, instead of setting aside the order or dismissing this case altogether, we just keep the status check that's on for May 2nd, just to preserve the grandparents' rights, just like Ms. Warnock stated. That is our request today. This is a heavily litigated case, as Your Honor already knows. We do have a trial in 4 short weeks, or about 5 weeks in this case. There are a lot of other issues that have arisen. Myself and Ms. Szyc are trying to get this matter settled if we can. And I know we're open, my client's always open to discussing the grandparent visitation matter. I just, at this point today, I'm not entirely sure what we're going to accomplish here.
So just correct me if I don't have the custody case in front of me, but I am very keenly aware of it. So the third weekend is mom's. Other than that, every weekend other than the third, grandparents pick up on Friday and drop off on Monday. Unless, I don't think I mentioned this, but unless it's like a 3-day weekend, then I would be willing to expand it. Like if we have a 3-day weekend, Labor Day, or any of those long weekends, they should be able to drop off on the day that school resumes.
That'd be wonderful. Thank you.
Okay, that way that does give, and so expanding it a little bit more, I don't think I addressed that at the last hearing, but if it's gonna be pick up Friday, take back to school on Monday, unless it's a 3-day weekend, President's Weekend, Memorial Weekend, and then they can return at that time. But I would agree, I do agree that preserving grandparents' rights is important, so I would agree, well, I'm not gonna dismiss this case, I will keep it open. We do have a status check in May, but in the meantime, with regard to the motion for reconsideration, I am granting that, and I am gonna go ahead and find that grandparents' rights are derivative from the father's rights. At no time are the grandparents been denied any access to the children by the father. The father does have every weekend from Friday pickup until Monday and or Tuesday, whatever day, if it's a 3-day weekend, to return back to school, with the exception of the third weekend, which does belong to mom. So at this point, the grandparents are in a position to exercise their time with their grandson during dad's derivative time. Now, in the event that the grandparents are being denied access to their grandchild, then that would be more appropriate to come before this court. Again, I'm not closing this case, so we will reconvene in May. But at this time, we do have a trial coming up just in a few weeks, I believe, in the custody case. At that time, we'll be able to resolve it. In the event, I don't know again how they're going to rule. But in the event that mom does get primary custody and dad's visits are very limited and grandparents seek to preserve their opportunity to come before this court, we will address it at that time. So we're not dismissing it altogether, but at this point, I am granting the motion for reconsideration and granting the relief requested by Mrs. With the caveat that I'm expanding dad's and or grandparents' derivative from dad's weekend timeshare in the event that it is a 3-day weekend. If it's Martin Luther King, I think the next one will probably be Memorial Weekend.
Just a quick question here. Sometimes a Friday is a no school day. Is that also a 3-day weekend, or are we just doing Monday holidays?
No, that would be fine. If it's a no school, if it falls within that Friday or that Monday, then I would be inclined to grant that extended time with grandparents picking up from school and dropping off. Again, the same behavioral order is still in place. Grandparents, I'm not dismissing this action, so your behavioral order is still in place. You're not to discuss the case, you're not to discuss sister or anything related to sister at any time regarding your time with your grandson, okay?
Your Honor,
Yes.
currently there's a 1 day a month. Is that also being, keeping that in place?
1 day per month.
It was like a Wednesday, but we needed to reach out, and I believe that they've requested the up close communication, but I don't know whether there was ever a response.
Did you have your Wednesday, sir, ma'am?
We've done one since December.
Okay, and how did that go?
Oh, it's just wonderful. We picked them up, we took them to the movies, went to dinner, and had them home by 8 p.m.
Okay.
As requested by.
Per month.
Yeah, and please, Your Honor, I'm sorry.
Go ahead.
Please, Your Honor, and then of course, however it works out, we would like a week during the summer for camping. I'm sorry.
We'll discuss the week at trial, because that's going to be after trial.
Okay.
But right now, with regard to the Wednesday, I would be inclined to grant grandparents that Wednesday, but it's going to be at mom's discretion on what Wednesday that would be. Ma'am, one Wednesday a month, I am going to still keep that for grandparents. That was their day with him to take out. They're under strict orders not to discuss the case, not to discuss your daughter's case with them. But you'll have to coordinate with mom. This is where I give mom that discretion to identify that one Wednesday a month. Okay? Now the summer, we'll put that on hold because we're going to reconvene in May after the trial. Okay?
So, Your Honor, everything that we had discussed previous with regard to the orders and the way that they need to communicate, that is still effective and in place?
That's correct.
Thank
That's
you,
still
Your Honor.
effective. We still want to ensure that you guys are communicating through talking parents. We want to ensure that all communication is respectful. The
And we
behavioral
would
order
bring
goes.
outposts, Your Honor.
App close, even better. It's fine. App close is fine, so long as it's free. And so we use app close, all communication regarding the child. Behavioral order is in place for all parties. You're to act respectful at all times. You're modeling behavior for the child. You're not to discuss the sister's case at any time. Okay, so we'll give mom that discretion for the one Wednesday a month that grandparents will have with and expanding dad's time, because grandparents' time is going to be derivative from dad's time. Pick up from Friday after school, unless Friday's a half day or there's no school on Friday, and drop off Monday, school starts, unless Monday's a holiday, and that's Tuesday. I'm only expanding it for that Friday and Monday though. If Friday and Monday are off, that doesn't apply to spring break. Spring break's the whole week, that belongs to mom, that was not discussed here at any time, okay? All right. Okay, Ms. Szyc, would you like to prepare the order from today?
Yes, Your Honor.
And no attorney's fees will be granted at this time.
Thank you.
Okay.
I'm sorry, Your Honor, if it's a 3-day weekend, what time can they pick up on Friday?
If it's after school, but if there's no school, then it would be, I want him to sleep at probably 8, 9 o'clock? I
In the
don't
morning.
know. What time does he wake up? I don't want him to have to wake up early on a school day. 9 o'clock?
He's usually up about 8 or 9.
Let's make it 9 then. Let's not make him wake up so early.
Thank you, Your
9
Honor.
o'clock, okay? All right, I encourage all parties to be able to coordinate with what I've provided.
Your Honor, just a clarification, was it not Thursday after school if there's no school
If
Friday?
there's no school Friday, that's
Okay,
correct.
thank
It would be Thursday. I apologize. If there's no school Friday, then it would be a Thursday pickup after school. If there's no school Monday, instead of drop off Monday morning, it would be Tuesday morning. Okay, but I'm only applying it to Friday and Monday
Yes.
weekends. If it's spring break, that's mom's time. Okay, and they get the weekends.
Thank you, Your Honor.
Okay?
Thank you, Your
All
Honor.
right. Thank you all.
Thank you.
Ms. Szyc can prepare the order. I'll counsel the count assignment.
Thank you.
Thank you all.